Start. The short question, comma, which arises for consideration in this appeal, comma, is whether the courts below, comma, namely, comma, the High Court and the Labour Court were justified in awarding full back wages to the deceased workman within bracket now represented by his legal representatives, the respondents here in bracket out after setting aside his dismissal order holding it to be bad in law and comma in consequence comma directing his reinstatement in service of the appellant stop para. The appellant is a state road transport corporation for the state of Rajasthan staff. The deceased Phul Chand was in the employment of the appellant as a driver staff para. The appellant dismissed Phul Chand from the service after holding departmental inquiry on the ground of dereliction of duties on various occasions while he was in the employment staff. The charge against the deceased workman was his continuous absence from the work, comma, which was proved staff para. Phul Chand felt aggrieved by his dismissal and filed an application before the Labour Court staff. The Labour Court, comma, by award dated 26/2/1996 held the charge against Phul Chand as proved but interfered in the quantum of punishment staff para. The Labour Court converted the punishment of removal from service to that of court stoppage / forfeit of 4 annual grade increments without cumulative effect decode and directed the reinstatement of the deceased workman in service with award of full back wages for the period of 13 years within bracket 16/11/1983 to 24/2/1996 bracket out staff para. The appellant under bracket employer, comma, felt aggrieved by the award of the Labour Court, comma, filed a writ petition in the High Court of Rajasthan staff. The single judge of the High Court, comma, by order dated 14/7/1998, comma, dismissed the writ petition filed by the appellant and affirmed the award passed by the Labour Court staff para. Being aggrieved by the order of the single judge, comma, the appellant filed intra-court appeal staff by impugned order, comma, the division bench of the High Court dismissed the special appeal and upheld the order of the single judge, comma, which gave rise to filing of this appeal by way of special leave by the appellant employer in this court staff para. Having heard the learned counsel for the parties and on perusal of the record of the case, comma, we are inclined to allow the appeal in part and while modifying the impugned order award 50% back wages to the deceased workman within bracket his legal representatives bracket out in place of full wages staff para. In our considered opinion, comma, the courts below completely failed to see that the back wages could not be awarded by the court as of right to the workman consequent upon setting aside of his dismissal / termination order staff. In other words, comma, a workman has no right to claim back wages from his employer as of right only because the court has set aside his dismissal order in his favor and directed his reinstatement in service staff para. It is necessary for the workman in such cases to plead and prove with the aid of evidence that after his dismissal from the service, comma, he was not gainfully employed anywhere and had no earning to maintain himself or and his family staff. The employer is also entitled to prove it otherwise against the employee, comma, namely, comma, that the employee was gainfully employed during the relevant period and hence not entitled to claim any back wages staff.